Welcome to the Constitution, line by line. My name is Mike Lee. I'm a U.S. Senator from Utah. Today we're going to be talking about Article 1, Section 1, Clause 1. This is the very first operative provision of the Constitution, which says that all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. It's important that the Constitution makes clear, here in this very first provision, that in order to make a federal law, you have to do it through Congress. You can't go through the executive branch, headed by the President. You can't go through the Supreme Court, which is the head of the judicial branch. You have to go through Congress. And that Congress is split up into two bodies, two different houses. The House of Representatives, where the states are represented according to population, and where members serve for shorter two-year terms. And the other house, the Senate, consists of two senators equally representing each state, chosen for terms of 6 years. In the Senate, there's supposed to be a slower, more deliberate process of making law. It's intended to sort of cool the legislative process and make sure that it doesn't move forward too quickly, too hastily. These are all important reasons why the Founding Fathers envisioned a system in which you could make law through only one branch of government. Critically, they intended this power, which is the most dangerous of the powers vested in their three respective branches of the federal government. They put the most dangerous power in Article 1, in the power belonging to Congress. And it's for that reason that we have to remember that this is the branch of government most accountable to the people at the most regular intervals. This was no accident. It was no mistake. They're giving a power that can't be delegated to the other branches to Congress because it's more accountable. One of the long-standing controversies regarding this provision of the Constitution involves whether or to what extent Congress may delegate its lawmaking powers to another branch of government or to some entity standing outside of one of the three branches of government. In the abstract, Congress may not do this. The task of lawmaking is itself considered non-delegable. It was for that reason that in 1935, the Supreme Court decided the Schechter-Poultry case and invalidated the National Industrial Recovery Act, in part because it gave discretionary power to the executive branch of government to regulate every aspect of commercial activity in the United States of America. And it did so with almost no standards that had to be employed under law. So this was a delegation of lawmaking power, huge amount of discretion to the executive branch of government. On that basis, the Supreme Court invalidated the statute at issue. In a more recent case, for example, a case called Whitman versus American Trucking, the Supreme Court again reiterated the fact that the lawmaking power is non-delegable, and it did so even while addressing an argument that Congress had unconstitutionally delegated its lawmaking power under the Clean Air Act by delegating to the EPA the power to make and interpret and enforce rules carrying the force of generally applicable federal law promulgated and enforced pursuant to the Clean Air Act. In that case, the Supreme Court of the United States, while reiterating the fact that Congress may not delegate its lawmaking power, concluded that it shouldn't and wouldn't and couldn't invalidate that act here because the standards, according to the court, were sufficiently clear as established by Congress that it wasn't appropriate for judicial intervention. In that case, Justice Scalia noted that the Supreme Court was confronting a question not just as to whether Congress had created too much power within the executive branch, but it was as though Congress had created a sort of new enterprise altogether, a junior varsity Congress, as he put it, something that would stand outside the three branches of government, but nonetheless exercise lawmaking power. In his dissenting opinion in Mistretta versus United States, Justice Scalia concluded, quote, "But while the doctrine of unconstitutional delegation is unquestionably a fundamental element of our constitutional system, it is not an element readily enforceable by the courts. Once it is conceded, as it must be, that no statute can be entirely precise, and that some judgments, even some judgments involving policy considerations, must be left to the officers executing the law and to the judges applying it. The debate over unconstitutional delegation becomes a debate not over a point of principle, but over a question of degree. The net effect of these cases is to say that on the one hand, Congress may not delegate lawmaking power. That belongs to Congress. It's constitutionally assigned to Congress because Congress is the branch of government most accountable to the people at the most regular intervals. On the other hand, the court has, ever since Schechter-Poultry was decided in 1935, been very, very stingy with how it wields that authority. And it has essentially stated that it's going to stay out of it as long as Congress comes up with these basic, intelligible principles that can guide the rulemaking power. The Supreme Court tends to consider that sufficient so as to allow the Congress to avoid having its acts stricken down as unconstitutionally delegating Congress's lawmaking power. Congress has become addicted to this process whereby it delegates rulemaking power. It delegates to a third party, usually an executive branch agency, sometimes a so-called independent agency, operating outside of the normal leadership framework within the executive branch of government headed by the President of the United States. And it has become addicted to it in the sense that this process gives members of Congress the ultimate sort of holy grail, which is the opportunity to take credit for laws that sound really nice without having to face accountability for laws that aren't very well considered. I keep behind my desk in my office 2 stacks of documents. One stack is usually a few inches tall. It's usually a few hundred to a few thousand pages long, and it consists of the laws passed by Congress in the preceding year. The other stack is often as high as 13 feet tall and can be nearly 100,000 pages in length in a given year, and it consists of the Federal Register. The Federal Register is the annual cumulative index of federal regulations as they're released to the public for notice and comment and later finalized. Many of those documents within the Federal Register contain legally binding provisions, binding on the American people, no less than an act of Congress. But the difference is that the small stack of documents I referred to, the laws passed by Congress, are made only by men and women who are elected for that purpose and stand for re-election every 2 years in the case of representatives and every 6 years in the case of senators. By contrast, the large stack of documents, those found in the Federal Register, are made by men and women who, while hardworking, well-educated, well-intentioned, and highly specialized, don't work for the people. They can't be fired because they never, ever have to stand for election, and most of them aren't really even accountable in any meaningful sense to anyone who is in turn elected. This is the focus of much of the debate surrounding Article 1, Section 1, Clause 1, which appropriately places the lawmaking power in Congress. When we look to the future and we consider how best to address Article 1, Section 1, Clause 1, and how best to address the issue of delegation of lawmaking power, a lot of people look only to the courts. Now, while it's true the courts can, and many people believe should, be the ones to take a look at this and to start enforcing the non-delegation principle. The courts are not the only answer. There are other answers we can look to. There are other ways of addressing the non-delegation problem. Another entity that we can and should look to is Congress. Congress itself could address this. Congress could enact legislation that in various ways could decide that any new exercise of executive branch rulemaking power, especially rulemaking power of the sort that imposes affirmative legal obligations on the American people, may not be self-executing, and that certain exercises of that rulemaking power could take effect only after they had been affirmatively enacted into law, passed by the House and Senate, and presented to the President of the United States for signature or veto. Thank you for joining us for the first episode of the Constitution Line by Line. If you've enjoyed this, please subscribe.